All right, well, it looks like it is 1:30 on the nose. In the interest of everyone's valuable time, and we have a lot of fantastic content to cover, so we are going to go ahead and get started. My name is Stacey Piazza. I'm the Executive Vice President of Compliance and Recovery Solutions at Sanderson Firm. I will be your moderator for the presentation. We appreciate you taking the time this afternoon to join us for this really important and relevant topic, Medicare Advantage plans, conditional payment recoveries, and what claims payers need to know in 2023. I'm going to cover a couple housekeeping items really quickly before we do our intros and dive into the topic. So first, if you all have any questions during the presentation, you can enter them into the chat section, and we will try to get to all questions as best as possible during or after the presentation. If for some reason we're not able to get all questions answered, I will try to record them, and then we can respond to you guys individually after the call. The webinar is being recorded, so if you would like a link to the recording or a copy of the presentation, you can email Heather or Brian or myself. So heather@sandersoncomp.com or Stacey@sandersoncomp.com. And I actually don't know, I think we might have Brian's email at the end of the presentation.
Yep, bbargender@humana.com.
Thank you, Brian.
Mm-hmm.
And there will be a very brief few question survey after the webinar, and we would greatly appreciate your feedback. This will help us make sure we're providing helpful and relevant content and providing, additional MSP related topics in the future that will be helpful for you all. So kicking off our presentation today is Heather Sanderson. For those that don't know her already, she's the founder and president of the firm. Heather's been providing expert support to the MSP community for close to 15 years now. She's definitely regarded as one of the foremost experts on it. During her lengthy career, has lobbied Congress for
Stacey, yeah. I'm sorry to interrupt. All of a sudden you were sounding great, and all of a sudden I'm having trouble hearing you. Maybe you could just get a little closer to the microphone. Thank you.
Let me try. So is this a little bit better?
Yes, just get a little closer. Yeah.
So during Heather's career, she has lobbied Congress for MSP reform, provided expert witness services in litigated matters, and is an award-winning blogger and writer, as well as a nationally sought-after speaker on all things Medicare secondary payer related, including Medicare set-asides, conditional payments, and Section 111 reporting. Heather's tenure has also included service as legal counsel for several of the nation's leading MSP compliance vendors, most recently serving as the chief legal officer of Franco Signor prior to their sale to Verisk. And in 2021, Heather founded Sanderson Firm, where she continues her passion for Medicare compliance. Joining Heather today is another certified expert in his arena, Brian Bargender. Brian is an internal consultant with Humana, one of the country's largest Medicare Advantage organizations. Brian has more than 20 years of experience in health benefits subrogation and MSP enforcement operations in both advisory and leadership roles. Some of Brian's current responsibilities include researching trends and legal developments, as you'll see throughout this presentation, that influence the coordination of benefits and payment recoveries for group health, Medicare Advantage, and Medicaid managed care plans. And in 2022, Purdue University awarded Brian a Master of Science degree in Legal Studies and Applied Legal Research. His master's degree capstone project identified MSP enforcement issues surrounding the PAID Act of 2020 and methods for evaluating how successfully the law facilitates MSP enforcement by Medicare Advantage plans. And Brian is also a certified subrogation recovery professional, CSRP designation. So as you can tell, it might have been a shorter list to list what they haven't done in MSP, but as you can see, specifically with regard to this topic, you guys have two of the leading experts in their field. So without further ado, I will kick it over to Heather as we dive into the topic.
Thank you. Thank you, Stacey. Thank you, everyone, for attending today. Thank you to Brian for joining us today. If some of you have been following us for a while, you might have attended last year. Brian joined us on a webinar. It was our most highly attended webinar of 2022, and already it's looking that way for 2023. I mean, there's so much going on in conditional payments right now, particularly in the Medicare Advantage plan conditional payment world, with so many changes legislatively with the PAID Act, and we'll talk about here shortly. And I think Brian's insight is just so invaluable. So I hope that you'll take some great tips away today. We're going to dive right in. As Stacey mentioned, we have a lot of content. First, I'm going to kind of lay a base layer. For those of you that don't have great familiarity with conditional payments, I'm going to talk about traditional Medicare conditional payments, how they differ from Medicare Advantage plan conditional payments, some recent legislation on the horizon, the PAID Act, which was enacted, the RAMP Act, which is floating out there. And then I'm really going to kind of turn it over to Brian. I want you to all hear from his perspective, working for Humana as a subrogation consultant. They're the largest, probably the largest MAP out there. Would you agree, Brian? The largest Medicare Advantage plan, or one of the top 3?
We are one of the top 2.
One of the top 2. So Brian's insight here is invaluable. And I know that you are all thinking about what you need to do with Medicare Advantage plan conditional payments now. So the plan is to address that today and talk about recent case law and other matters. Let's dive right in. So traditional Medicare, right? Conditional payments. So conditional payments is it's a Medicare payment for Medicare covered items and services where there's another primary payer available, right? It's important to understand that with Medicare, there are 4 different types of Medicare, essentially, from a main standpoint, right? There's traditional Medicare Part A and B, right? Traditional Medicare Part A pays for, hospital coverage and the like. Medicare Part B pays for outpatient items, right? And now a growing area of Medicare is the Medicare Advantage plan space. That's also known as Medicare Part C. So Humana is one of the top 2 Medicare Advantage plans across the country. There are several thousands of MAPs across the country, though. There's some regional small ones. But generally, and Brian's going to talk about this later in the presentation, we're seeing more and more Medicare beneficiaries opt for a Medicare Advantage plan for their healthcare coverage rather than enroll in traditional Medicare. And the 4th component of Medicare would be Medicare Part D. That's the prescription drug component, also offered by private drug plans, right? So a Humana or an Aetna or Cigna, if you will, also offers this prescription drug benefit. So for a long period of time, we were only concerned generally with traditional Medicare conditional payments, right? We just were dealing with traditional CMS and working with their contractors there and only caring about that. But over the years, the Medicare Advantage plan conditional payments have become a growing area of concern. And that's because Medicare Advantage plans did vie for and are beginning to collectively win rights to double damages if not reimbursed, just like traditional Medicare. So it's really important to understand the difference there between the different types of Medicare. We all know, traditionally and under the regulations, if Medicare is not reimbursed for conditional payments and has to file a lawsuit to recoup their conditional payments, they have a right to file for double damages. And that double damages right accrues 60 days after the issuance of the settlement check, right? And ultimately, very important to understand that under the regulations, Medicare and Medicare Advantage plans have a right to pursue generally any party to the settlement, whether that be the Medicare beneficiary, the Medicare beneficiary's attorney, the employer carrier, or the insurance carrier, of course, right? And so even if this responsibility in your settlement agreement, if you decide to punt the conditional payment obligation to the Medicare beneficiary or their attorney, and they don't reimburse Medicare, it's important to note that Medicare Advantage plans and traditional Medicare may still, seek recovery despite what's in your settlement agreement. It sounded like you had something good to add in there, Brian.
I was going to say that still is a common misperception that a settlement agreement is going to insulate the payer from responsibility. And different Medicare Advantage plans approach this a little differently. So there's not a consistent practice across the industry, but more often than not, Medicare Advantage plan will seek, in the event of a liability settlement, they will start by seeking recovery from the beneficiary. If the beneficiary is not responsive, or if they've already dispersed the funds, that's when the plan says, okay, we are going to go back to whoever issued that payment. A key distinction between Medicare Advantage and Medicare Part D and traditional Medicare is traditional Medicare has some avenues available to them that Medicare Advantage does not. So if a beneficiary does not reimburse Medicare, that debt gets referred to the Treasury Department or to the Department of Justice, depending on the circumstances. And CMS could still, as you said, decide, we're going to go back to the payer anyway. So but that Treasury Department of Justice route isn't there for Medicare Advantage. And CMS still says we have to collect the money. If we don't have those options available to us, we have to consider litigation.
Very good, excellent point. Thank you. Yeah, and so, we're seeing, not only Medicare Advantage plans, obviously, vying for their recoveries via the routes that they have. As Brian mentioned, they don't have the right to go to the Treasury or the Department of Justice because it's a separate recovery right, that Medicare Advantage plans have. But traditional Medicare is also exploring all their different avenues of recovery. Just recently, in February of 2023, we saw a recent action by the Department of Justice regarding a plaintiff law firm that was continuing to enter into settlements with Medicare beneficiaries, but failing to reimburse the Medicare program. And so a press release was put out that this law firm has now entered into a settlement agreement with the DOJ to resolve allegations that they failed to reimburse Medicare. And interestingly, and this is not the first time we've seen a DOJ action like this with a law firm, but what they're basically requiring the law firm to do is not only pay a settlement amount, but also designate someone at the firm that handles MSP matters and regularly trains their staff. And it's a whole host of responsibilities. So it's like, generally we're seeing the Medicare program and the Medicare Advantage Plan programs, kind of at times, picking different parties of the settlement to show that all parties are responsible in reimbursing Medicare. And as the DOJ commented here, that we cannot simply rely upon, a law firm to reimburse Medicare, and all parties are responsible. And this is just the beginning of more to come. Okay, so traditional Medicare, that's, we all generally, I think, understand that. Most of us, traditional Medicare, it's important to note too, and I think this is a common misunderstanding. I know, Stacy, you see this in our recovery division at Sanderson Firm, and Brian, I'm sure you see this as well. Mm-hmm. Confusion that traditional Medicare, which is, the recoveries for conditional payments are handled by the BCRC and the CRC. They do not pursue or do not have information or will not provide information or dispute with you on Medicare Advantage Plan conditional payments. Humana does the recoveries themselves or might hire, a subrogation contractor to do those sorts of recoveries. But if you get, like, let's say, a zero paid letter from the BCRC or CRC, and that there's been an entity out there paying, it's more than likely that the Medicare Advantage Plan conditional payments are accruing and that the Medicare Advantage Plan has a claim for recovery. I sort of wish, a wish list item, if CMS were listening, I wish they would actually put in all their conditional payment correspondence that these amounts do not include any Medicare Advantage or Part D conditional payment amounts. That has to be separately dealt with the private plans themselves. Mm-hmm.
And the notice letters that come out for traditional Medicare have a statement that's similar to that, but doesn't go quite that far. And it basically says this is with respect to payments under Part A or B. And that's pretty much the end of the sentence. A lot of plaintiff attorneys in particular misread that or misunderstand that statement to say that means there's no payments at all made by Medicare. They may not understand the distinction between traditional Medicare and Part C and D.
And one thing I wanted to point out as well is that even though technically a Part C or a MAP plan may replace your Part A and B benefits, so you don't have both at the same time, but because MAP plans are elective, you can have both during dependency of the claim. Somebody, when they first get on Medicare, may have had traditional Medicare for 2 years, and then they voluntarily enrolled in a MAP plan, and now they had that for the last 2 years. So you could be working with two, potential liens and contractors in play, depending on the coverage of your claim. You could be dealing with Medicare and Medicare Advantage, so it's not always just one or the other.
That's right. And then we're seeing, recently, Stacy, maybe you want to comment, a lot of Medicare beneficiaries changing plans annually. So if one of our clients have had a claim open for a number of years, there could be both traditional Medicare and multiple Medicare Advantage plans out there that have a claim for recovery.
Absolutely. And primarily in workers' compensation claims that tend to be open a little bit longer than your liability claims, we definitely are seeing multiple MAP plans, in play for a lot of these claims. 2, 3, we've seen up to 8. I think we've actually seen up to 12. So
that's pretty wild. So yeah, so as I mentioned, the Medicare Advantage plans are private plans. They're an alternative to traditional Medicare. Humana is an example of one of the big MAP plans, and obviously Humana, Kaiser, Aetna. Right now, I think the most recent statistic, Brian, is about 50% of the Medicare population is enrolled in Medicare Advantage plan. And we're expected to see that continue to trend up, right? I mean, we're just seeing, you guys are seeing at Humana more and more enrollees on a daily basis. Is that right?
Yes, it is. It's running a little slower than projections. By the end of the decade, more than half of Medicare beneficiaries will probably be in Part C. That seems to be consistently projected. And Part D is probably around 80% of all Medicare beneficiaries right now. So most Part C members will also have Part D coverage bundled together, but a large percentage of the people that remain in traditional Medicare also pick up Part D coverage as a standalone option.
Right, so they can have coverage for their prescriptions, right? That's what the Part D plan is for. So, but yeah, very unique. Like Brian mentioned earlier, you know, different avenues of recovery, right? So MAP plans don't have the right to go through the Treasury or the DOJ. They have the right to file litigation. They also can, you know, use a recovery agent such as Rawlings or Optum, a subrogation company that might pursue recovery. And then the dispute and appeal options are not exactly the same as Medicare, right, Brian? I mean, I know that Humana is great with taking into account good faith disputes, but essentially the process is not the same. And if the parties were not satisfied with the MAP resolution on the conditional payments, I mean, the QIC does step in at a certain point, right? But the appeal options are not exactly the same. Maybe you can explain that.
Sure. So for Medicare Advantage disputes, and it's much clearer if a plan coordinates benefits with a, say, no fault or work comp, and denies coverage when that coverage is known to be available. In that case, there's an appeal process that's comparable to what happens under traditional Medicare. There's a determination, a redetermination within the plan. Then that redetermination automatically is forwarded to the qualified independent contractor, and they review it. They'll either reverse or uphold. If they uphold, then everything goes into the same process that's used for traditional Medicare. There's some gray area about how that applies for disputes from a beneficiary. It does seem like it should, but if you look at the tracking or the decisions that the QIC publishes abstracts for, there's very, very few or very low volume of recovery dispute determinations that get published by or abstracts that get published by the QIC. I know they happen, they're just very few and far between. CMS has not extended any appeal rights yet to primary payers. So there's a primary payers process under traditional Medicare for disputing conditional payment reimbursement. There isn't a formal process yet under Medicare Advantage and Medicare prescription drug. The larger plans and their sub-row vendors or recovery vendors all have some kind of informal process. They will consider, a good faith dispute, and they'll negotiate over the amount that's owed. But if things fall apart, there's not a clear direction of where things are supposed to go.
It's like there's a disconnect or an opening in the MSP law, and it's like at some point this is going to become so big that we're going to need to probably legislatively fix that, right? Because I think CMS takes the position that MSP recoveries from MAP plans are under your all's umbrella, right? And they feel like we don't touch that. We just do traditional Medicare Part A and B recoveries, but someone's got to address this as this becomes more of an issue. And I think this is a great time to kind of segue into the PAID Act. So for those of you that are not familiar with the PAID Act, then this can kind of explain a lot of the commotion around Medicare Advantage plan conditional payments over the last couple of years. So on December 11, 2020, and effective December 11, 2021, the Provide Accurate Information Directly Act was signed into law. Very enthused about being law, because prior to the PAID Act, as part of your Section 111 query process, right? So when you all are determining if you have a Medicare beneficiary and you're entering the big five, the first name, last name, date of birth, social security number, and gender, Before the PAID Act, Medicare was only returning traditional Medicare Part A and B enrollment to payers. And this was a problem because here you had Medicare Advantage plans being pressed on, as Brian mentioned, by CMS saying, you got to pursue your recoveries, and the payers want to pay the Medicare Advantage plans back. But unless the beneficiary, knew this information offhand or provided this information, then, the payer didn't know and would simply just resolve the traditional Medicare conditional payments. So the PAID Act was a simple one-page bill, and it simply just requires CMS to return the Medicare Part C, the Medicare Advantage, and the Medicare prescription drug, the Medicare Part D enrollment information to payers, so that, if the payers want to proactively resolve, these conditional payments, they may do so. There's no requirement to contact the Medicare Advantage plans if you learn of the enrollment post-PAID Act. But obviously it's a best practice, right? Because of this double damages right that the Medicare Advantage plans have. So as of December 11, 2021, Medicare is returning the query response information on Medicare Part A, B, C, and D enrollment information to you all as payers. Now, what we're seeing and what's interesting is that there's a different level of understanding with the PAID Act and what to do with this data. We're finding at Sanderson Firm, some payers are on it. We're contacting all the Medicare Advantage plans and we're tying everything up. Some are getting this information in their query response files and not necessarily doing anything with it or knowing what to do with it. We've encountered some payers out there that are like, wow, we need to make a change to our claim system to actually input this information and do something with it. So it's all across the board, but nonetheless, the risk is the same. If you have knowledge of a Medicare Advantage plan conditional payment out there, or you're aware that one of your injured parties is enrolled in a MAP plan, it would behoove you to proactively resolve these conditional payments, or there's an outstanding liability out there. But the PAID Act was a really welcome change for the industry, but I think this is what has caused a lot of the uptick. Brian, maybe you want to talk about it. I know it's interesting timing with the implementation of the PAID Act with COVID. How have you seen,
Sure.
increased traffic or more inquiries or requests for conditional payments since the PAID Act's been passed at Humana?
Well, it's been challenging because we anticipated there would be some additional increase in inquiries because of the PAID Act. Unfortunately, it kind of goes back to what you were saying with the payers not having reached consensus on how they want to use this data. We could not. We knew there'd be more correspondence or more inquiries coming, but we had no way of forecasting how much. And some part of the background on this also is that CMS implemented the regulation or implemented the change in the Section 111 response files that are returned to payers, and communicated a lot to the payers about how that was going to work. There was very, very little communication with Part C and D plans, other than make sure your coordination of benefits address is up to date and still accurate. That was it. There was no direction on what CMS recommended for plans to do or whatever. So we were waiting for the inquiries and correspondence to come through, and trying to forecast how much staffing we have to add to without knowing how much we could expect to receive. During the first half to maybe the first 3 quarters of 2022, we really didn't see that much of an increase. And it was difficult to tell if the increase we were receiving was because of the PAID Act, or was it rebound in settlements as the pandemic started to ease up. We've really had now, I would say, I haven't seen the latest numbers, but compared to this time in, say, 2019, we are easily at high triple-digit percentage increases in inquiries, if not low quadruple-digit increases. But I've heard from other counterparts at other plans, they're not seeing the same increase, so it's a little strange. But I would say it's creating a backlog with a lot of plans not being able to respond as quick as they're used to responding, because they weren't able to anticipate how much they would have to staff up to handle the correspondence that was coming in.
Do you think there's some level of payers saying, wow, we know Humana's out there with a conditional payment lien, and we're a little bit daunted by Humana, because Humana historically, not recently, but over the last decade or so, has filed double damages litigation against not only insurance carrier payers, but also law firms, saying, hey, you ignored our request for payment, and we're now going to sue you for double damages, and has established case law on the books establishing the Humana led some of those efforts in those cases.
Yeah, that very well could be. We do have discussions with some of the larger payers, but those preceded the PAID Act. So it's possible that there are payers that want to talk to us because they, we will try to cooperate on these issues, and they recognize that. Or there might be other payers that want to reach out because they are afraid of a litigation risk. I would actually argue, that based on what we're seeing in some of the current litigation, it's not necessarily the large payers you have to watch out for. It's the smaller ones that historically have not really done a lot of work, and have been less diligent about enforcing MSP in the first place. And they have outsourced a lot of what they do to companies that are much less hesitant to litigate. And so you, as a payer, to protect yourself, you almost have to contact everybody, not just the big names.
Excellent point. So just briefly going to touch on another piece of MSP legislation that's hanging out there. I don't know what you've particularly heard about this RAMP Act, Brian, but my understanding is that the Repair, Abuse, and MSP Act was it's been introduced and I believe reintroduced this year. It hasn't really gained any traction, but what the legislation is trying to do is remove the ability to the private cause of action permitting double damages. It doesn't seem like it'd be supported by the Medicare Advantage plans. Because of the historical case law establishing this right, it gives the Medicare Advantage plans that teeth to be able to recover conditional payments. So I know that this might be popular in some industries, but I'm not really seeing a lot of movement as of recent. Have you heard anything? Has there been an ask for support from Humana or the other plans?
Yeah, I am only tangentially involved in lobbying, so I really can't speak to this. But yeah, I think it would be a tough sell with Medicare Advantage plans, even though we don't, we use private cause of action, the larger payers. You look at the litigation that's been filed. Humana's filed some lawsuits. I believe CVS Aetna has filed some lawsuits, but really as an industry, we use the private cause of action as a last resort. And there are other entities out there that do litigate quite a bit. Even though we use the private cause of action as a last resort, I think we still like to have that tool available because, as I said before, we can't refer something to the Treasury Department. We can't refer something to the Justice Department. So it's, this is our last line of defense if we have to recover the money. CMS has continually told us that. If we run into a roadblock where we can't, this is, the RAMP Act takes away that option. So, assuming it passed, there would probably be some kind of adaptation from Part C and D plans to work around it somehow, I imagine, but I can't forecast what that would be.
Yeah, and that makes sense. And I think it's now been reintroduced this year for the third time, and it's really never garnered a lot of support. So I expect to see that fall off, and that the private cause of action sticks around, because like you said, Brian, there's really not any other enforcement mechanism. Should Humana or other MAP plans have to enforce the reimbursement rights. So we talked about this already, but just want to keep it all on your radar that the Medicare Advantage plan enrollment continues to increase. Right now we're at 49% of eligible beneficiaries in a MAP plan. It's increasing year over year. Intended to likely continue to increase. So when you think about your Medicare Advantage plan enrollees, it's probably about half of your claims population that are on Medicare or on a Medicare Advantage plan. So it's really important to take a look at the data that's coming back in the query response file from CMS. So Brian, talk to us a little bit about expectations for Medicare Advantage plans, and what does the law say you all need to do?
So the two big regulations to watch out for with Medicare Advantage are 42 CFR 422-101 and 422-108. Just last week, 422-101 was updated. It used to refer to, we have to follow the general direction in Medicare manuals or coverage determinations and related instructions that apply to traditional Medicare. So essentially, if CMS said that a contractor has to follow these rules for administering Medicare benefits, then Medicare Advantage and Part D have to also. What changed this was published back in December, but finalized last week, is that now we have a obligation to follow the same laws that govern traditional Medicare, unless there's a specific exemption that applies to Medicare Advantage. So the two big exemptions for Medicare Advantage are hospice benefits and end-stage renal disease, I believe. There might be something else I'm missing, but those are Medicare Advantage cannot provide hospice benefits. Everything else, if it's a benefit that would be applied to traditional Medicare, if a claim's presented to a Medicare Advantage organization, we have to process it the same way traditional Medicare would. Medicare secondary payer decisions are also benefit determinations. So the same rules that apply. And this reg was promulgated based on concerns over prior authorization and medical necessity determinations, but it's an open-ended writing. It's not limited to just those issues. So the same criteria that CMS would use in reaching a determination on whether to pay or recover because of MSP rules also applies to the Medicare Advantage program. That's going to cover, I think that's probably going to touch on some of the things we were just talking about with appeals as well. Because those are considered under separate federal regulations. A decision to enforce MSP rules is a benefit determination, especially on post-payment recovery. So I would watch this space. I think there's going to be more coming. I talked about the private cause of action being a tool of last resort for a Medicare Advantage plan. Understand what CMS wants us to do is enforce the Medicare secondary payer rules the same way that CMS would. We're under contract. We have to provide the same kinds of benefits that traditional Medicare provides, but we're also in competition with other Medicare Advantage plans out there. So, it's not like the TRICARE contract that Humana has. That contract's issued exclusively to Humana for half the country for a set period of years. Every year, somebody can, a Medicare beneficiary or a treatment provider can decide they no longer want to work with Humana. So we've got this competing interest of we've got to be effective at doing what CMS wants, but we have to do it in a way that really doesn't cause widespread harm for beneficiaries and treatment providers. So we have to be kind of surgical in how we enforce MSP, and do what we're supposed to do, but not go overboard with it. And also, the MSP enforcement efforts that we do are just a tiny fraction of what a Medicare Advantage plan does. We're essentially self-contained Medicare billing and enrollment and claim processing and all of the other stuff. We can't shut down the operation to make sure that we're enforcing the MSP rules we have to do everything that CMS would do, but we can't stop the rest of the show in order to avoid paying for something, for example. So really what we want at the end of the day, and the Advantage plans in particular, not necessarily their vendors, we want and nothing against the vendors, but our interests don't always totally align. We want the ability to demonstrate to CMS we are enforcing MSP, we're doing our best to comply, and we want whatever process we come to be predictable and expedient and cost effective. without upsetting the apple cart on everything else. And I think if payers understood that and where we're coming from, I think there's opportunities where we can, or our interests align in a lot of this. Next slide, please. So, what we have to do, and this goes really, a lot of this is, I mentioned 422-108. That's the regulation that says we will enforce, CMS expects us to enforce the MSP rules in the same way that CMS would enforce it. So that means, we have to avoid payment when we know there's ORM a no-fault carriers accepting claims, work comp carriers accepting claims. We have to avoid payment when we've got that confirmed. Typically, what we will also do, though, is we will send notices to all of the parties that we identify. So if we know the beneficiary has a claim against somebody else, and we try to do this before settlement whenever we can. So we're not waiting on a carrier to contact us, or at least not the bigger payers are all doing some proactive method of identifying claims that should be investigated and sending notice when they think there's an MSP potential opportunity, either present or coming up down the road because of a settlement. So notices go out to all the involved parties. If a payer tells us we already paid this hospital or this ambulance service or whatever, our standard practice, and this is pretty consistent across the industry, is we go back to that double paid provider and say, you have to pay us back. That's not the payer's responsibility. And if there is something that was paid and no fault or work comp could have covered it, and say no fault hasn't been exhausted on other claims, we will go to recover payment from those carriers. And again, 422-108, we follow the same rules that CMS does. So if it's something that's not payable under work comp because of work comp law, then we just need to know that. If it's something procedural, like, well, you have to give us a claim form, or you have to, we only pay providers directly because that's our company policy. That's not going to fly with a Medicare Advantage plan, because if you could make that argument with the Commercial Recovery Center, you can make that argument with the Medicare Advantage plan. If you can't make it with the Commercial Recovery Center, then don't even try it with the Medicare Advantage plan. You would have to cite a specific law that says you don't have an obligation to pay. So next slide. So now liability is going to be a little different. We're still going to send out notices to everybody, but we're going to look to see, is there no fault, say a car accident, is there no fault available? Well, then we're going to avoid payment and hopefully not get the liability carrier involved at all. Notices will go out, and we again try to do this pre-settlement. So there's a lot of data mining on claims, looking for diagnosis codes that seem to be injury related. We will look for police reports to identify payers if we don't get a response from the beneficiary or their attorney. In the past, we've used court records to identify parties that are involved in lawsuits and try to get them on notice before they file suit, or before they settle the claim and pay the beneficiary. We can't always do that, especially if we don't get cooperation from the beneficiary, but we're not waiting for the carrier to come to us. The PAID Act can supplement that process. And then as far as I mentioned before with 422-101, benefit standards that apply for traditional Medicare also apply for Medicare Advantage. So that means the waiver and appeal process. It also means something like the attorney fee reduction formula that applies for traditional Medicare also applies. If the attorney cooperates with recovery, there should be a fee reduction formula. That's where you may find some inconsistency in the interpretation within plans, but generally speaking, that's how that rule should be interpreted. And there's very little case law on that right now. There's some that's emerging that all enforces that interpretation. Next slide. So I'm not going to get into the details. I know we're going to have some questions that we'll have to answer. So how the PAID Act fits in with Section 111. In the upper left corner, you see, the carriers are sending their information under Section 111 to CMS. CMS does the eligibility check. They will respond if there's a Medicare and eligibility. And now, because of the PAID Act at that stage, that response is going to identify who the Part C and D plans are for the past 3 years from that inquiry date. That is the earliest opportunity a carrier has to update their systems, and then, if they choose to, reach out to those plans and find out if there's conditional payments. Now, then the carrier goes through the rest of its process. They get to where they're reporting ORM or TPOC or whatever. CMS, the BCRC is the CMS contractor for traditional Medicare. MSP enforcement, they update CMS systems to say, okay, there's an MSP opportunity here. What a lot of payers don't understand is, after they do that, they pass that same information, or not all of the same information, they pass a good chunk of that information onto the Medicare Advantage plan. We don't necessarily rely heavily on that data. We use it, but our process is really to get in front of settlement or TPOC. So we'll find out frequently from this source after settlement if we haven't been contacted prior to settlement, or if our investigation didn't get anything prior to settlement. So good reason to be proactive in using the PAID Act if you aren't already. Next slide.
Yeah, and just briefly, Brian, as far as, the PAID Act information being an earlier opportunity for payers, and we're seeing, with some of the Medicare Advantage plans, they're taking a long time to,
Yes.
provide the Humana's got it a lot together, but I know we've been working with one Medicare Advantage plan in particular that let us know they're 6 months behind in response times. I know Humana's not that far behind, but can you give, the folks on the phone some idea on, response times if they reach out to Humana?
I don't know what our inventory is like right now. Historically, we were probably about 2 weeks. We're past 30 days right now. I really hate to say this, but I think, especially if you're contemplating settlement, you really need to be looking at probably 45 to 60 days to be on the safe side. We still run into an awful lot of instances where somebody contacts us during mediation and we can't help them. We'd love to be able to, but we have 30 days of inventory we have to address first before that last minute inquiry. So yeah, I think planning out 45 to 60 days is, if you're talking TPOC, is better. But I also want to point out, if we don't have to pay the claim because somebody tells us no fault's accepting it, or work comp is accepting it, we don't get into these situations waiting to provide information at the time a claim is being settled because we haven't paid anything.
Right.
The recovery vendors don't necessarily like that. They're most of the business model, and again, I'm not faulting them. Their business model is predicated on they're going to get paid if they recover payment, not if they help us avoid payment. So if a no-fault carrier or a work comp carrier says, here's what we're accepting, don't pay these claims, we can avoid a lot of this mess to begin with. Just very briefly, I'm not going to get into this a lot. A question comes up, if we get, do we get all of the data that carriers submit to CMS under Section 111? The blue circles, what high level gets submitted, the green circles, what comes over. In the middle is where they overlap. You'll notice on the far right side of the slide, there are some things that we do get that are not submitted by the carriers under Section 111. They could be coming from, provider reports to CMS, or the BCRC's own investigations, or attorney reports, or something like that. A couple of different sources, but the key, going back to that other slide, is yes, we get this information. It's not everything we would like to have, and it comes too late for us to use it to get ahead of TPOC, for example. So you can refer, I think we're sharing the slides. People can refer to this later or ask questions if they want afterwards.
A question on the MSA information that comes over to the MAP plan. So what happens there and with that information?
So there's 2 separate files that come over. There's a Part C specific file and a Part D file. The Part C file is coded to flag a record when it belongs to an MSA administrator. And we will get, who the administrator is. We generally are going to also have the work comp carrier as a separate record, so we can link those together. And then we'll have the diagnosis codes that are supposed to be covered by the MSA. We don't get it's very high level stuff. On the Part D side, we get a little more detail that's structured. And we will be told that the MSA is supposed to cover drugs. We will not be told what drugs have to be covered by the MSA. Currently, in my understanding is CMS is reviewing its current instructions, but the current instructions say we are supposed to contact whoever the administrator is and find out what drugs are included in the MSA and then block payment for those drugs. If a drug is used for a MSA related purpose and a non-MSA related purpose, Medicare will allow it. But it's going to depend on what the documentation in the MSA says. And I think we're mainly worried with some of the drugs that would be used for, I don't know, less frequent conditions. If it's like I don't know that an MSA is frequently going to cover, say, ibuprofen or acetaminophen or something like that. But those are drugs that would be, a lot of listeners, unfortunately, probably take those on a regular basis, and they're not under MSAs. Those aren't the drugs CMS seems to be worried about. It's more the drugs that are used for severe chronic conditions that probably are going to be a focus. So, PAID Act. If you're a carrier and you do want to cooperate or do want to at least alert a plan that you may be settling a claim or you may be providing coverage. The key word is may. Don't assume that. I know there's some hesitancy from some payers that assume they're automatically going to be trigger a demand if they contact an MA plan. If you explain you're contemplating settlement and make that clear, you're not going to trigger a demand. It's only when settlement has happened that really it should be an issue. Or if you are accepting claims for work comp or no fault, we're still going to look to see if we've paid anything before we contact you. So at a minimum, you want to provide the Medicare beneficiary ID number, the name, the date of birth, and the loss date. And anything less than that means it's going to take even longer for us to identify that beneficiary and respond. So if it's a John Smith with a date of birth of April 19th, we have to sort through all of the other John Smiths. The data that CMS is providing in terms of the benefit package ID number and the contract number, those are not specific to an individual. They only tie that individual to a plan. And Humana has hundreds of them. If it's a name like John Smith, there might be multiple John Smiths, even with the same date of birth or the same state of residence under those two combination numbers. So really, MBI name, date of birth, and loss date are what we'd look for. Loss date is going to help us. In some cases, the beneficiary may have termed before we paid any claims, so that is a good shortcut for us. It's even better if you can provide the coverage type. So let us know: is this no fault? Is it work comp? Is it auto liability? Medical malpractice? Just give us some basic facts of loss in that sense. The diagnosis codes that are being looked at. If you're the payer, are you accepting ORM? If it's settled or pending settlement, and if you're the payer, also provide the claimant attorney info. There are some plaintiff attorneys that will not communicate with Medicare Advantage plans, as we talked about before. And ideally, and this goes back to those double circles, we would love to be able to get the same data elements that a payer reports to CMS if those data elements are available. So if it's settlement is still pending, you're not going to necessarily know what diagnosis codes you're accepting or going to settle on or whatever. But all that other stuff is going to speed up the process of getting a response from a plan. And if it's an MSA, back to what I was just saying, if there's an MSA contemplated as part of a settlement, especially a work comp MSA, we occasionally will encounter liability MSAs. give us the information about the diagnosis codes and medications that are going to be covered by the MSA, because we're going to have to come back and get that information later. So one of the issues that's come up with the PAID Act has been privacy concerns. So there's, I would say the two biggest issues that I've heard from a payer standpoint are, one, they don't want to trigger a demand when they're not ready to pay. And that I've already explained. The other one is there's concern over what they can actually share. And there are some payers that believe they can't share the MBI and the social or the date of birth, et cetera, because of some state law. What you can do on some of this is, communicate with the beneficiary prior to settling the claim, or communicate up when the claim is submitted and get their permission rather than waiting till settlement to do it. And check the Medicare eligibility again well before settlement, not just to get a faster response, but you're heading off those issues before they're likely to present a roadblock if you wait too long, especially the privacy issues. If you can do it, make exchanging information a condition of the settlement, or getting authorization at some point of the process. Just getting an authorization is always going to protect you if the state has some kind of law that applies without the authorization. Next slide. So, but there's a different argument. So even if you think that state law governs you, so 422-108, the friend that I talked about before, 422-108F extends CMS's authority for MSP enforcement to Part C and D plans. And that includes a right to obtain information to enforce MSP. That's the moment any part of the Medicare program pays for a injury-related care, there's an automatic authorization extended to Medicare to obtain any information from any party that has it necessary for MSP enforcements, regardless of state law, regardless of contract language or whatever. It overrides everything. That specifically the release of information is under 41124, which is encompassed in the authority granted under 422-108. But there's some practical arguments also. So even if you don't think you can release information, go back to that flowchart diagram. CMS is going to give us most of the information eventually anyway. We're going to get it 45 to 60 days after it's reported to CMS. I think that seems to be about the window. You're in a much better position to contact us and give the information before settlement than for us to find you 45 to 60 days after settlement. The PAID Act also kind of has an implication that there's an authorization. Congress wouldn't have given you the information to use if there wasn't some kind of implied authority to use that information to contact the plan. Clearly the legislative intent with the PAID Act was to facilitate discussion between payers and Part C and D organizations. So other PAID Act considerations, I mentioned this before, those contract and benefit numbers, be wary of those. They're not going to help you find a unique individual. Also, I'd be aware, I think things have gotten better, but I would watch out for the plan address because sometimes that's not the street address or recovery unit mailing address for the plan. So you may have to allow some additional time if you're using that address. I would contact the plans before I would contact their recovery vendors. I'll use Humana as an example. We have, I think, 5 vendors that do different parts of the recovery process. The vendor you talked with on one claimant may not be the vendor you'll be talking to on the next claimant. So you're better off going directly to the plan than trying to go to a vendor contact, unless of course the plan has told you just contact Optum or contact Rawlings or whoever it is that they prefer to have handle this stuff for them. And I would also just be extra careful around privacy and confirm the match. If you have a hesitancy about sharing information, start by confirming the match, and then share the information once you're confident that yes, the information CMS gave you belongs to an individual that's a Humana member or whatever. Some plans like Humana, this is where we run into an issue with some of the direction from CMS. There are plans that are much more, they have a higher risk tolerance threshold with regard to privacy than some other plans. There are plans that do not want to talk to payers because they believe they're not allowed to for whatever reason. There are plans that will, if a payer contacts them, whatever you need, we'll get to you. Humana's in the middle. If you're a payer, we don't have a problem once we verify who you are of giving you information to facilitate the MSP dialogue. If you're a vendor working on behalf of a payer, we want to see some authorization either from the beneficiary or from the payer, because unfortunately, there are companies out there that claim they represent Medicare Advantage interests, for example, that really don't. And we're afraid that could happen on the other side as well. So, be aware of that. Heather, did you want to cover this one?
Yeah, just briefly, we're getting close on time, but just want to make you all aware of this recent case. It's called MSP Recovery versus Metro General Insurance Company. And the gist of the case, which I find very interesting, is that the 11th Circuit Court of Appeals held that essentially Section 111 reporting constitutes constructive knowledge of MSP obligations, basically meaning if you're receiving paid act information about a Medicare Advantage plan enrollee or a Part D enrollee, and you're not acting upon that, even though the paid act doesn't require you to reach out to the plans, the fact that you have knowledge via the Section 111 process means that you have the constructive knowledge of these obligations, and then that could be a cause for double damages. So this is significant with regard to the paid act. Won't get into MSP recovery today, but just briefly, law firm out of Miami, Florida, filing numerous lawsuits across the country against various payers, and they're not stopping. They're backed by significant private equity, and they're continuing on. And the case law continues, and so that the Aetna versus Big Y Foods case is another interesting Circuit Court of Appeal case. And also, we've got now 4 Circuit Courts of Appeal that have finding that MAP plans have this double damages right under the MSP private cause of action. So I think that we're just going to continue to see all of the sister circuit courts fall in line and find the same.
Yeah, there was I forget the citation on it. There was at least one district court that this was prior to the PAID Act and without regard to Section 111 reporting. The district court told the payer, look, you could have found, you maybe didn't know who paid for the claims. You clearly had medicals claimed. You knew that CMS claimed there was no lien under or conditional payments under Part A or B. If you didn't have constructive knowledge, you knew you were at risk at that point. So don't say you had no way of knowing somebody else paid. You had the opportunity to avoid a double damages suit in that case.
For sure. Just briefly, this is just an example of a letter that MSP Recovery has sent out. This they're trying everything. They're trying to say they have automatic double damages. If you've got an MSP Recovery letter coming in, feel free to consult with us at Sanderson Firm. We'll help walk you through that. There's not always an obligation to respond to these letters, but I do want to. We have to, unfortunately, keep it going. We're only got 2 minutes left. There's so much to talk about, and we only have 2 minutes left. But I do want to make sure to get everyone's information, the information as far as Brian's contact information and as well as mine. I'm going to skip through this, by the way, and I think Stacy mentioned this. We are happy to provide a copy of today's deck. I also see, and we are recording, happy to provide a copy of the recording. Also, I see there's Stacy. Wow, we've got over 10 questions in the queue, and they're really, really, really good. So my brain was churning as we're finishing this. I'm like, man, last time we did this webinar, Brian, if you recall, we went 90 minutes. It was just far too long. So I said today, I'm like, there's so much information to cover. Maybe we'll do a part 2, but I'm also thinking I might do some kind of written follow-up to you all on your Q&A, and I'll work with Brian on that. There's just so much unknown here. But I did want to make sure everyone gets your contact information, and very important, right? The subrogation referrals at Humana.com. That's where, parties are looking to get, the MAP conditional payment information from Humana. That's where they need to go, correct?
Yes. Yeah, and I see there's a question. I'm just kind of scanning the questions. That's where you would send if you're requesting a payment information from Humana for a Humana member, that's where you send it. That's your fastest way of getting it. If you're not getting a response through there, you can contact me directly. I may not be as fast at responding as they are sometimes, but that would be the way to go.
Perfect. Well, we are at 2:30, so I'm going to stop today's presentation, but I want to again thank you, Brian, so much for your expertise today. You are, a great gift to the industry, sharing your knowledge and your time here today. Thank you so much. Thank you, Stacy, for hosting and moderating. Thank you to all of you that have attended today's webinar. Would love to hear from you. Let us know if Sanderson Firm can assist with your MSP needs, or if you have any questions or information's up on the screen, and reach out if you'd like a copy of today's presentation or the recording to watch again or share with your coworkers. Thanks again. Wishing everyone a wonderful day. Thank you.
Thank you, everyone.
Thanks.